Our special coverage of the guilty verdicts for 3 white men in the murder of Ahmaud Arbery continues. I want to bring in criminal defense attorney Sue Ann Robinson. Thank you so much for being here, Sue Ann. I actually want to start off by just acknowledging that this case almost didn't happen. The now former Brunswick District Attorney Jackie Johnson, who was initially in charge of this case, was indicted by a grand jury for obstructing justice and violating her oath as a public officer because she initially prevented authorities from arresting the McMichaels, presumably because she knew Gregory McMichaels, who was an investigator in her office until he retired in 2019. And then a judicial circuit DA, George Barnhill, took over the case and ultimately ended up recusing himself because he had a conflict of interest too. But not before he sent a letter to authorities defending the choice not to indict and claiming the McMichaels were following a burglary suspect. Now he may also be in legal jeopardy. It took 3 months to arrest these now convicted criminals, and I would love your reactions to all of that. Tell us how this case could ultimately have gone a different way.
It could have all absolutely gone a different way, and it's truly a testament to the champion of this entire case, you know, Wanda Cooper Jones, who did not give up. You know, no matter how many times she was told, no, we're not going to continue to look into this, she kept on. And that's the bittersweet part of the victory is, as you so eloquently stated, Aisha, it almost didn't happen. And but for this Black mother saying, listen, I'm not going to let this go, it absolutely certainly could have gone the other way. And it shows us, all of us, what it took for us to get to this point of justice, for us to be able to celebrate a jury verdict. It took a Black mother saying, I'm not going to give up on this. I'm not going to give up. And obviously a DA to get indicted by a grand jury, for multiple DAs to be appointed on the case until Linda, who ultimately prosecuted the case. So it takes so much for us to get justice. And then, of course, with the video, which was the most key piece of evidence. And the only thing that's concerning me today, right now, outside of my celebration, is the fact that the video evidence was the key piece. Because we have to remember, these things are happening all the time, unfortunately. You know, I take the calls every day in the office. And, you know, they're not on video. So fortunately, in this case, there was a video, there was a fighting, strong Black mother there, but there's so many other cases where it's not on video. And I don't want the video or there actually being footage of these types of events to become the only pathway to justice.
Yeah, no, I want to come back and talk a little bit more about that video, but I don't want to lose this piece that you were mentioning about the mother's activism here, and that the only reason that this finally, after, what is it, 80-something days, that these guys got indicted was because mom kept pushing, and then certainly there was a caucus of activism happening around her. And I wonder if you could just kind of explain to us, how is it that a district attorney can kind of look at a case, shrug their shoulders? I mean, if you look at the excuse for not indicting, I mean, they pretty much presumed innocence for the white men, that they were doing the right thing under Georgia law and that they were, you know, suspicious, and that then deputized them to go run off and do what they did. And they presumed a sense of guilt about the actual victim. Talk to us about how it is that a DA can just simply do that and move on and not actually get knee deep into finding the facts in a case like this.
Well, I'll say this, it's a non-progressive DA, and I would say lazy, and I would say biased DA that acts in that manner, because the seat of justice in any given county is in the prosecutor's office. It's their job, once they receive a report from a police agency, to research the information and find out if charges can be brought. And so in this particular case, they kind of took the police officer's report at its word and said, okay, well, self-defense sounds good. And believe it or not, Aisha, this happens way more times than not, that DAs will just say, well, we're not going to charge these cases. And if there isn't a strong parent who is able to get some strong legal representation and get momentum behind the case, there's so many cases that fall through the cracks. So again, the champion of the case obviously is Miss Wanda, and her being able to get everyone involved, and then of course the video coming out. But absolutely, the district attorney is the one who decides on the charges. So if they say there's no charges, what we understand now and what everyone is learning is that you got to keep pushing. You got to keep pushing. And if you know what the facts are, and all Miss Wanda did throughout the case is she always had faith in the facts of the case.
Last night, our BNC colleague Candace Kelly joined me to talk about the case and helped us understand the differences between malice murder and felony murder. We saw 4 counts of felony murder for each of the defendants in this case, which is a total of 12. And I'm wondering, why were there so many felony murder counts for just one victim?
The felony murder counts go to each felony that was charged. So there was 3 felonies actually charged, the 2 aggravated assault charges, and then the false imprisonment was another felony. So as to those 3 felony charges, a felony murder charge attached to each of those, and then a felony murder attached to the actual murder charge itself. So felony murder is something that follows. If you're committing a felony and someone dies, then one band, one sound. Everybody is going to be guilty because you're involved in a felonious act. And so that's why the state charged it that way. They charged the felonies, and then they charged felony murder for each of the possible felonies. And then you can see in the jury's actual verdict which felonies they found which defendant guilty of.
Right. We know that a federal trial is also scheduled for February of 2022. Can we expect the racial animus that we saw throughout the murder trial to continue in the federal proceedings?
I sure hope not.
And what civil action, by the way, do we expect Arbery's family to take too?
Well, I certainly hope that the defense does not take the same tact that they did in this case. Obviously, it didn't work for them. Talking about Ahmaud's hygiene didn't work for them. Summoning black pastors didn't work for them. Moving for mistrial because it was windy, because it was cold, because a lot of people were outside, a lot of black people were outside, did not work for them. So I'm hoping that they do not take that same tact just because it's not something that's good for their client, not because I don't think they're guilty. In terms of the civil remedies that are available, obviously, you know, as we all know, there was no actual police involvement. You know, there's a legal theory that they were deputized, which is something that the family attorneys are obviously exploring. And then there's other liability against the defendants themselves, which I'm sure will be pursued.
Criminal defense attorney Sue Ann Robinson, thank you again for breaking all of this down with us here and for joining me on Amplified. Appreciate you. Don't go anywhere. Our special coverage of the verdict in Brunswick, Georgia continues next on Amplified.
And trusted us to bring justice for Ahmaud. And the verdict today was a verdict based on the facts.
Yes.
Based on the evidence.
Yes.
And that was our goal, was to bring that to that jury so that they could do the right thing. Because the jury system works in this country. And when you present the truth to people and they can see it, they will do the right thing.
That's
and that's what this jury did today
That's right.
in getting justice for Ahmaud Arbery.